Hello and welcome back to the Data Privacy Lawyer. My name is Funmi Owolabi and I'm the principal attorney at the firm. Today's review, we're going to be looking at some AI terms. Let's have a look. I'm going to quickly hover over products. The reason I'm doing this is because it'll help my understanding of the terms to be more clear. So it looks like AI code making you nervous. Ship trusted code at AI speed with the world's first autonomous validation platform. Okay, so I'm interested in what they consider to be validation. Is it validating the code? It seems like this is going to have less personal data in some capacities, but I can't know without having more understanding of the tool. But I reviewed this because I wanted to see the implications it has on the AI terms that we're about to review today. Ship at AI speed. CircleCI keeps your code tested, trusted, and ready to ship 24/7 with minimal human oversight. Oh, cool. Okay, let's go back. So these are the AI terms entered into between the business and your employer or entity you represent. So I want to make a quick comment on this. The data protection laws, the thresholds required under most data protection laws applies to a business entity. Most businesses are going to have some type of data protection implication, depending on the geography where they offer the service, and then also depending on what the threshold is in the geography where they're headquartered. There's lots of different nuances in each geography. I don't know where this product is being offered. I presume it'll be offered globally. What would be the restriction on offering this in the United States outside of like the European Union, for example? Now, the terms. Whenever businesses are considering drafting terms, they're looking at what are the implications from geography to geography. They're not just looking at where it is that they're headquartered. Now, I didn't see and I don't know. Let's actually take a look at Contact Us. On the Contact Us page, it generally will give you insight into where the company is headquartered, but sometimes it does not. Sometimes that's not something you're privy to. On my intake form for my firm, I always ask for where is the business headquartered and then where does the business offer their products and services. Those are different. Just because you're headquartered somewhere doesn't mean that those are the only data protection laws that are going to apply to your business. The reason I originally had highlighted and your employer or the entity you represent is because it appears that this solution is being offered to a business, and businesses are generally the entities that are meeting the threshold for the data protection laws. So there are obligations this company is going to have if they process personal data, and there are obligations you as the customer are going to have based on the data protection laws. They are not the same. Each company has its own obligations. If this business only sells its product in the United States, the obligations it has are restricted to the United States. If you, the customer, have personal data that you process in the Asia Pacific region, you need to understand how that is going to implicate your use of this business's tools and services. If they are going to be obtaining personal data from your employees in the Asia Pacific region, they're going to process that. The obligations then move to them, irrespective of the fact that they anticipate their tool is only going to be sold in the United States. You need to be able to understand that as a customer. They need to be able to understand that as a service provider. It's your responsibility to know what your obligations are. And it's your responsibility to enforce specific contractual obligations on service providers that you interact with if they are going to be obtaining data outside of the United States. You have to tell them that. That's not their responsibility. They have their own privacy program. And that's just an example, right? I don't know what this company is doing and I don't know what the customer is doing. I can only give you insight based on my work in this field and what I see generally amongst businesses, the types of questions that they ask me, etc. Okay, I love that this has definitions. I've talked about this severally, not just in the terms, but also in the privacy notice. I think it's very, very valuable to have definitions because of the audience, right? Not everybody is a privacy lawyer. And sometimes customers or businesses don't have dedicated privacy counsel to help them understand what it is they're agreeing to. They might have a general counsel, but that doesn't mean that the general counsel has specific knowledge about data protection principles, data protection obligations. Us as legal professionals, we generally will specialize. My specialty, data protection. That's what you've seen on this channel. That's what you'll always see. If there are additional terms in the AI terms that implicate other areas of the law, it's your responsibility as a business to get counsel into how it impacts your business. I like the definitions, and I'll go back to why I like the definitions. If you don't have any counsel at all, and a lot of businesses don't, the individuals involved in your contractual process need to be able to understand what they're agreeing to. You might not have a privacy counsel to help you explain or understand what these terms mean. And even if your supplier is listing what the definition is, how do you know what the implications of an AI provider is on your business? How do you know what the implication of an AI technology is on your business? Yes, they've put a definition here, but how do you reconcile the definition with scope, restrictions, input and output? What a lawyer is going to generally help you do is understand, read these terms into these provisions and explain the risk to your business. When I am working with clients and they're saying, hey, can you draft me a privacy notice? I need to be able to be very, very familiar with your company to be able to provide advice to your company based on what your company does. What your company does is not what another company does. Every company is different. So the advice is going to be different. How I would read this for an education customer is going to be different how I read this for a healthcare business, right? Because the privacy obligations are going to be different. Sometimes the risk may be too high to your organization, and that's something that I'll be able to articulate to you based on my review and my understanding of your company. Okay, I want to talk about input and output. Now, this is where the data protection piece comes in, right? Input means any data, software code, or other content or information that is provided by you to be processed by the AI features. Input is hereby added to the definition of your data or customer data in the agreement. Okay, I want to talk about this. These terms should never be read on their own. When you do the due diligence, you need to look at every document that is included in the contractual process. We can see here that they've added terms or definitions that don't exist in these terms. Your data or customer data. You need to read this document and the agreement together. And you need to have your privacy counsel reconcile any inconsistencies between the AI terms and the agreement if they exist. And you need to be able to understand the obligations you might have based on what's listed in the terms if they're different to what's in the agreement. You need to read all of them together. We can see here that there's a definition of your data that's not listed here and customer data that's not listed here. And you need to be able to understand how this addresses any of the provisions below. It's really useful to have a privacy counsel review that for you because I don't have access to what customer data constitutes. So my review of these AI terms is going to be limited. But I still think it's valuable for businesses to place it on the site for a couple of reasons. The main reason being, when you do due diligence, you can kind of get some type of insight into their privacy practices, what's acceptable, restrictions, and you can send these to your privacy counsel for review during the request for proposal stage. Because sometimes they won't share a true agreement with you until you've decided which product you want as a business, but this is on the website, right? I'm just reading this as a regular consumer. Yes, I have a data protection expertise value that I can add to that, but this is just what ordinary consumers have. And it may be that some businesses won't share internal agreements with you until you've decided what product you want to obtain from them. So you can do this background research before you even engage with them from a contractual basis. All right, I think it's really valuable to read this. You need to understand what constitutes input if you're going to be working with a service provider. This will influence the personal data they process on your behalf as a data processor. Now, they're providing you a service. They are acting on your instructions. Your instruction is, hey, I need this product for building optimization. The purpose has been determined by you. The purpose is to build optimization. The means is obtaining a license to their platform. That's the means in which you are going to fulfill building an optimization. So you're the data controller. They are the data processor in that they're providing you the tool. They're acting on your instructions. Hey, I'm the customer. I want to build optimization. Then their response is going to be, okay, we can help you with building optimization. What is the instruction on this? And then you'll give them your specification. We need so, and so. They're acting on your instructions. Their responsibilities when they act on your instructions are clear under the data protection laws. They need to adhere to that. Your responsibilities as the data controller who determines the means and purpose of processing is also been written out under the data protection laws. You need to look at what your obligations are in each geography where you'll be providing them your personal data in order for them to build the optimization. So there's a lot that goes into this. I still think it's valuable for customers to understand what it is they're signing up for and also understand what type of value can be added by engaging with a privacy lawyer. Because this is not something that I think is understood by every single business group. Every single business group may not have the level of understanding of what the risks may be when it comes to their data. They've made it clear it's your data. You have responsibilities. They have responsibilities too, but essentially it's your data. You've got the customer data. Now, the reason it's valuable to know and continue to highlight this is because your obligations don't end just because you are working with a service provider. it's still your responsibility to know what's going on within your organization, because it impacts the type of privacy policy you as a customer can place on your website. I'm going to click this quickly. Let's see. I want to talk about third parties. I'm hoping that they have a section there. Okay, great. Now, I didn't read this entire thing. The reason I wanted to highlight this sentence is because personal data we receive from other third parties. Let's say, for example, you're the customer and you're interacting with this supplier. And interacting with this supplier, you need to draft your own privacy notice that goes on your website. You need to be transparent with your users about the fact that you're interacting with a third party. Because if they're helping you with building optimization, that's not something that you internally are doing. You're actually procuring a service from a third party. And when you draft your privacy notice on your website, you need to be articulate about that to your consumers if their personal data is implicated. And that is an obligation you have under the data protection law. So interacting with any third party is an obligation you need to fulfill as a customer. If you are going to procure services from them, you need to understand what they're doing so that you can articulate it to your consumers as well. So there's a lot that goes into the flow. There's a lot that goes into creating and optimizing a privacy program. I've swapped between public-facing documents because I want you to see how they all interact with one another. It's not as simple as, oh, I've drafted a privacy notice, that's the end of my obligations. It's not. And there's a lot of public-facing documentation that is implicated by privacy in addition to this software as a service agreement, right? So I really hope you enjoyed this review. If you have comments about my opinion, leave a comment below and I'll see you in another review.